Hello, everyone, and welcome to Uncivil Law. And for today's coverage, we cover the ongoing issues relating to Donald Trump, as it seems that Donald Trump will be sentenced tomorrow morning in New York in Judge Merchant's court relating to the felonies relating to the bookkeeping fraud that he was previously convicted of. We turn our attention to the order that was released by the U.S. Supreme Court earlier, and we'll read the entirety of it because it's not very long. The application for stay, which is an injunction, to Justice Sotomayor, and Justice Sotomayor here is mentioned because she is the circuit justice. So every circuit in the United States has a justice who can unilaterally act and just do things. They don't very frequently. In fact, it almost never happens, but they technically can. So New York is in the Second Circuit. The Supreme Court has previously determined that Justice Sotomayor is the circuit justice for the Second Circuit. They make these decisions in advance. So she's the circuit justice. That's why she's mentioned there. So she's mentioned there because she technically has the power to unilaterally act. She could make the decision herself. So anyways, the application for stay that was presented to Justice Sotomayor in her capacity as circuit justice, and then by her referred to the court, which, pretty much happens every single time, is denied for, among other things, the following reasons. First, the alleged evidentiary violations that President-elect Trump's state court trial can be addressed in the ordinary course of appeal. Okay. All right. Second, the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sense of unconditional discharge after a brief virtual hearing. It's interesting to me that the Supreme Court is taking the intent of the judge as gospel here. That seems to me like slightly odd, because here's what the judge says they're going to do, but until they do it, it doesn't really exist. But they're treating it like it really exists, which is kind of odd. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would have granted the application. So you only need 4 votes for a cert grant, but you do need 5 votes for a stay, which is an injunction because it's an order. So if this were a request to hear the case on cert, then 4 votes would be sufficient. It's the rule of 4. But because this is a stay, because it's an injunction, then not so much. So yeah, it's interesting that they wrote it this way. It's also interesting to me on a technical level that it completely unaddresses the issue of jurisdiction, which I think is interesting. 4 justices apparently are of the view that there's jurisdiction here, or at least it seems like they think that. And the other 5 either don't think there's jurisdiction or think that this can be adequately resolved somewhere else. So tomorrow, Donald Trump will be sentenced to an unconditional discharge, which means that there's no penalty. And that sentencing is supposed to happen, I think, at 9:30 in the morning Eastern time. I could check the exact time, but it's fairly early in the morning that's supposed to happen. So anyways, he's going to be sentenced. And the implications of this, incidentally, are like non-existent. In sort of like the effect of it is non-existent. So there's been some debate, between LawTube about whether or not he was a convicted felon without being sentenced. We've looked at the relevant New York law. New York State would say yes, but every state would say once the sentencing is put in place that he's convicted. So this seems to be like, for example, why he was able to vote in the Florida elections, for example, because even though New York under New York law would have considered him to be a convicted felon under New York law, Florida doesn't make that determination until you're actually sentenced. And so he was able to vote in the election. But Florida also says that once you've completed all the penalties associated with your conviction, you're able to vote in the election. So he'll be able to vote in the midterms because there's going to be no penalty associated with it. So Florida says once you've done all your time and you've done everything associated, you've completed every burden associated with your sentence, then you can still vote. So Donald Trump still has the right to vote. He can vote in the midterms. I guess he can't own a gun or possess a gun. But he has lifetime Secret Service, so probably wasn't looking to pack heat anyway. So probably not a huge deal for him. It has no impact on him being president. I don't know whether or not a felon can get a security clearance. I imagine it's difficult, but I'm not necessarily sure it's impossible. There's probably been felons who've gotten security clearances before, but it just doesn't matter with the president because the president is the original classifying authority. He is the one from which the classification starts. So it doesn't really matter because they don't go through a background check or a security clearance. He is the security clearance. So it doesn't impede him in terms of getting access to classified information or secure information because he's the fountainhead of the authority. So he's ultimately the one that gets to make the decision in the first place. So it doesn't matter. It doesn't really inhibit his right to travel. Some countries might ban you from traveling to them if you're a felon or otherwise, but they could have done that anyway with respect to Trump because he's the head of state and they could have denied him from coming on the basis of just declaring him persona non grata, right? Because he's the head of state. So they could have denied him anyway. So it doesn't have any meaningful implications. So the only practical implication is, the implication we already had, which is that people get to just call him a convicted felon and say he's a convicted felon and just get to trumpet that, being the thing. Assuming, for as long as this conviction maintains, because I think in the long term, it's likely that this conviction will be vacated. So, they'll have their moment of glory for the moment. They'll have their moment of glory where they can be like, he's a convicted felon, he's a sentence convicted felon. But it won't surprise me if eventually down the line, the sentencing or the conviction is vacated and, the whole thing is thrown off the books. But they have their moment of glory. So they get to have their moment. And that's about the end of that. Can he pardon himself? No. It's state level offenses. He has no authority to pardon himself. So, no. He can't pardon himself. So, that is that. So, I guess he'll make his virtual appearance before the judge tomorrow morning. And, yeah. See if I can find the exact time that he's supposed to be sentenced. I believe it's 9:30 in the morning. Trump, New York. See if I can find the exact time. It could take a second. Find the exact time. I'm pretty sure it's early in the morning. Would pardoning himself for the federal predicate nullify the state charge? No, it would not. No, it would not nullify the state charge. Convicted felon remains convicted felon for the moment, Artie. For the moment, until sometime down the road, his conviction is vacated by some court. Which, fair enough. Yeah, I guess. Is it lifetime for Secret Service or 10 years? Good memory, by the way. That's a good question. So that's a really good question. It is lifetime. But they did change the law at one point, so it was going to be only 10 years. But they changed it back when Obama was in office. So that's a very good question, Michael. So you have a very sharp memory for asking that question. Yeah, the United States Congress changed it so that the protection the president got would only be for 10 years after office. But then and that happened when George Bush was in office, they changed the law. But they changed it back. Congress changed the law back when Obama was in office. So to change it back to lifetime. So it is lifetime, but sharp memory. Good question. No live feed of it because of New York? Yeah, I don't believe there's going to be a live feed of it, no. I'm not sure there's anything really less to say about it right now. Just pulling up a few articles to see if I can find anything more about it. Justice Barrett didn't say yes, which is interesting. So Justice Barrett didn't grant yes, and Chief Justice Roberts didn't grant yes, which is, I suppose, less surprising. Justice Barrett didn't say yes, which is, I suppose, slightly surprising. He may get Judge Cannon, who will bend the knee. Judge Cannon has no jurisdiction over this, Artie, because Judge Cannon is a federal district judge out of Florida and has no jurisdiction to hear this case, as I'm sure you well know. But there are serious federal issues here, so I would think that he'll get review. He'll get review either from the New York Court of Appeals, the Appellate Division, or the New York Court of Appeals, or a federal appeal on a collateral attack, either from the Federal District Court or the Second Circuit Court of Appeals, or ultimately the U.S. Supreme Court. But not Judge Cannon, because she's a Florida judge, and you know better than that, Artie. So don't bring misinformation in my chat, because that's dumb, and you're a lawyer and you know better. A Judge Cannon, a sycophant? It doesn't take a sycophant to think that there are serious legal issues here using the U.S. Supreme Court's test under Trump versus United States. There are serious issues here relating to immunity, relating to the evidence that was presented to the jury. And there are serious evidentiary questions that raise serious issues about the evidence that was used and the legal validity of that evidence under the relevant legal test. And so then you just are back into basically a harmless error analysis at that point. And it's pretty easy to say that there's a lot of material that shouldn't have been used and it isn't harmless error. So it doesn't require a sycophant. It just requires someone who looks at the law and obeys it in a reasonable way. Or it could be a reasonable way. I mean, there's a lot of uncertainty around relating to this, but that's the state of the law right now, is some uncertainty, because we're not exactly sure the full scope of the immunity, but there are some serious issues relating to the immunity. So there's that. What else can I answer for you? I'm just trying to read some articles about this right now. See if I could find the exact time. Trump had faced theoretically up to 4 years in prison, although he would never get that because they were Class C felonies with no records. So he was never going to really get prison time. Thank you, Mr. IFS, for being a member for 20 months. The Rushdie case? I don't know anything about the Rushdie case. I haven't been following it. So I don't know anything about the Rushdie case. I don't even know what you're talking about. I have no clue what you're talking about when you say the Rushdie case. No clue. Are we getting snow? No. Yeah, 9:30 in the morning on Friday. I was right on the time. So 9:30 Eastern time. So exactly 12 hours from now, they'll be sentenced by the New York trial court merchant. I'm assuming by a virtual appearance. I assume he's going to appear via Zoom. He's the author that got stabbed multiple times and lost his vision at a Chappaqua amphitheater 4 years ago. Okay. Rushdie. Okay. All right. Okay. No, noted. Noted. Now that you mention it, like, that sounds vaguely familiar. It sounds vaguely familiar. All right. Can Trump pardon himself? No. These are state level offenses that he cannot pardon himself. No. All right. Well, I guess I'm going to sign off for now since there's no further discussion. It's been nice hanging out with you guys. Until next time, I've been Uncivil Law. Hope all's well. Cheers, my friends, for now, and goodbye.